Hi, everyone. Welcome to the webinar. My name is Sarah, and I'm going to be acting as a host for today. We are joined by attorney Rachel Amspoker, and she is going to be talking with us about what qualifies as an unfit parent. Rachel is one of our expert attorneys at Johnson Law Group, so we are very lucky to have her here today with us. There will be time for questions and answers at the end of the webinar. So please feel free to ask those questions at any point in the webinar by typing into your chat box. As always, your participation, registration, and questions are anonymous. And we are so happy that you were able to register and join us today. So Rachel, I will let you go ahead and take it over.
Okay, thanks, Sarah. As Sarah said, I'm just going to be presenting on what qualifies as an unfit parent in Colorado. Just as a little disclaimer before we start, this does not create a attorney-client relationship, and this is not official legal advice. So with that said, let me just share my screen. There we go. Actually, I'll just present it this way. Okay, so one really important thing to keep in mind generally when we're talking about getting rid of someone's parental rights is that these are really highly protected constitutional rights. A parent has the right under Amendment 14 to the US Constitution to the care, custody, and management of his or her children. It's not really taken lightly by the courts, so they do take extreme caution in terminating these rights. They're only going to do it in cases when it is absolutely necessary, when the children are going to be harmed by the relationship with a parent for whatever reason. And talking a little bit about single parent families, which are pretty common now in the United States, although in 1968, 85% of children lived with two parents, that number is now 70%. So there are a lot of single parent families in which one parent is really not involved. So children may exclusively live in a single parent household if one of their parents is qualified as an unfit parent. So that would restrict their constitutional rights, as I said before. So, I mean, the question is why would a parent be considered unfit, and how does the judge make that determination? And also, how do you go about that if you are wanting to declare an ex-spouse or an ex-partner unfit? So generally, the broad question is whether the parent has failed to meet the child's needs or if they have endangered the child's well-being. So there's a number of factors, and I'll go through all of them. There's about 7 or 8 that go through whether or not a parent is unfit. So the first factor is whether the parent has a mental health disorder or other disability that limits his capacity to care for the child. This could be any number of things, something diagnosed and something serious that makes it physically or emotionally impossible for a parent to care for the child. Events, or another factor is events that have happened in the past that prove that a parent is unfit. Some sort of accident that maybe led to an injury or trauma for the child. Doesn't necessarily have to be a physical injury, could be an emotional trauma or witnessing a very serious event. Another factor is any situations in which the parent has been physically or sexually abusive towards their child or to other children. Whether the parent has been violent in the past, that can include domestic violence, any domestic violence that the child has witnessed or that they haven't really explicitly witnessed, but maybe they're aware of, things like that. And then this one is pretty common if a parent abuses substances like drugs or alcohol to an extent that they cannot provide proper care for the child. You know, someone who is addicted to drugs or in and out of homes and just isn't able to provide a stability for the child because of their addiction. More factors. any evidence that the parent is neglecting or has neglected the child. Could be any number of things for that one. If they're not providing a safe home for the child, if they're not watching the child is left alone. Any cases in the past in which the parent had been neglectful, which resulted in the injury or death of other children. So kind of like one of the factors earlier, if there has been harm to another child, that kind of goes to show that the parent could cause harm to this child. It's not necessarily dispositive, but it is something that a court would take into account. And then finally, whether the parent has already terminated the parent-child relationship. I won't touch on this a ton in this presentation, but a parent can also choose to terminate their rights, which would make this process a bit easier. If someone wanted to terminate their rights, they still have to go through a different process. The court isn't just going to automatically terminate their rights just because they want to. Things like going to therapy, filing the petition, and working with the court on that would be important. I thought that a common question might be incarcerated parents, whether that is a factor for unfitness. Alone, just being incarcerated is not enough to terminate parental rights. It can be a factor affecting parental unfitness. And also, it just goes to show, like, logistically, whether or not the parent could care for the child. If you're in a prison sentence for 6 years, I think it's a lot more likely that a court would find that you're unfit because the child won't have your influence in that time. But, in a different situation, if you were just in prison for a few months and you were up for parole or something like that, wouldn't necessarily go to show that the parent would be unfit for a really long time. So just wanted to go through a couple examples based on real cases. So in this situation, the mother wasn't involved. The father had a history of domestic abuse to the mother, and he had not accepted responsibility for that. He was incarcerated at the time for domestic violence and also for a DUI. I believe there were 2 counts of domestic violence. He had not contacted the child since he had been incarcerated. He was denied parole in part because the parole board considered him to pose a continuing threat to society. And then the child also had prospective adoptive parents who the child had a strong relationship with. And those were the basic factors. What the father wanted was to do a treatment plan, which had already kind of been set up in a previous assessment. He wanted to do a treatment plan that would gradually enable him to get to be a better parent and eventually to maintain his parental rights. Assuming that would be after he got out of jail. So I guess the question is this enough to be determined unfit? In this case, it was. This was a Colorado Supreme Court case in 2006. The court talked about how it can be an option for them to order a party to follow a treatment plan, like what the father wanted, but they don't have to find that a treatment plan would be successful. In this case, they found that it would not be successful. Due to his previous actions, he was continuously unable to care for the child, and also he was going to be in prison for a while. He was denied for parole, so it didn't really look like it was a situation where things would get better. Another example, so in this case, the Denver Department of Human Services had removed the children from the home originally right after they were born because she had been using controlled substances. The children were eventually returned, but then there were reports that she was using meth and there were domestic violence and abuse situations happening. So throughout the investigation, a supervisor found that the children had an ambivalent attachment with the mother and that she wasn't displaying any strong parenting skills. There were some incidents that she was a bit aggressive with the children and upset them. And then just her lack of consistency was a really big issue. She previously had never lived in a suitable home for them. The kids had lived in 13 residences or she had lived in 13 residences, and the kids had changed homes and caregivers 4 times when they were just 4 years old. So there was a lot going on there. But this was not enough to declare her an unfit parent. At the trial court, they actually did say that she was unfit based on her lack of consistency with the children. She didn't have the permanent home, and they were worried about the children not being able to build connections with their community. But the need for permanency and consistency weren't enough on appeal to terminate parental rights. And that's because just when we're looking back on it, on the rights of parents to parent their children, these proceedings are trying to enable that goal as well. They're trying to fix the parent-child relationship if it's possible. If it's not possible, at that point, parental rights would be terminated. But the courts and like all the other involved people don't want this to happen. They don't want the extreme case, but if it's in the children's best interest, then that is when it would be appropriate. So just that's a bit of background on the factors and everything for declaring a parent unfit. As far as the process, I'll go ahead and talk about how you would actually go about it. So just to say first, if you're worried your child is in immediate danger, obviously calling the police is the first step. Wouldn't want to go through this process if there's an immediate danger concern, would have to go through the police first. But if you're concerned that your ex-spouse or partner is an unfit parent and your child is not in immediate danger, definitely you can go through this process with an attorney and try to declare them unfit. So similar to an original petition for dissolution of marriage or something like that, you would start by filing a petition or a motion. It would request a hearing and the court would schedule a date for the hearing. The parent who is filing the motion and the ex-spouse or partner will both attend the hearing, where the judge will review the evidence and decide if the parent is unfit. The judge will review all of the factors that have been presented that I went through earlier, and will determine if a parent's conduct or condition is unlikely to change within a reasonable time. This is really important because it's their final determination. They're trying to see if it's appropriate to terminate the rights and take such an extreme measure for the long term. So they can consider a lot of things to make that decision, whether any changes have occurred during the proceeding, whether the parent has actually, tried to make things better since the proceeding started, or if they've been uninvolved. They're also going to look at the parent's social history. If it's an addiction situation, have they had a long history of addiction? Have they taken steps to remedy that, or are they're continuing on that path? And then also whether the nature of the parent's condition is chronic or long-term in nature. So that it really is like a fact-specific question based on whatever issues that the parent is currently experiencing. Yeah, like I touched on in one of the cases earlier, the judge can also create a treatment plan. So this would be a step-by-step process to help a parent regain parenting skills. This could include steps like the parent has to maintain a safe home for the kids for like at least 6 months or something like that. The parent has to hold a stable job. And this treatment plan can be tailored to the issues that the parent is experiencing and can address any of the main concerns that might lead to might cause harm for the child in the future. So if they don't go through the treatment plan route, and if they do declare the parent totally unfit, the court would terminate the parent-child legal relationship and the other parent would be granted sole custody. That means that the other parent would have full decision-making and full parenting time. and would just be fully responsible for the child. If both parents are determined to be unfit, then the child would go to another guardian or to foster care. And if a parent-child relationship is terminated, child support is off the table for the parent whose rights have been terminated. Yeah, so like I said earlier, the court is not going to easily declare an unfit parent. So if this is something you are interested in pursuing, it's really important to present a really strong and compelling claim that has a lot of evidentiary support. In addition to examining evidence, the court will also do a psychological evaluation of the parent. There may be, DHS, child support service or child services and things like that are going to be involved in this. There might be a lot of other people who are going to be conducting interviews and talking to the kids or talking to the parents to see what's best for them. So you might be wondering how to strengthen your case. That will just be from getting as much documentation as you can get. Critical documentation could be police reports, if there's been a legal issue or if the police have been called for any reason, definitely important to get those reports. It can be hard to get police reports depending on the county and the jurisdiction, so that is something to prioritize. Medical records, if there have been any injuries for the children or any injuries to another adult or another child, those medical records are also very important to get. And then drug tests, if there's an addiction situation, any drug tests that show that the parent has been using would be very useful. Long term, it's not going to be just based on the previous few months. Like it's definitely appropriate to look into the history of the family and the history of the parent. So older documentation can definitely be used. And witnesses as well. Anybody who witnessed anything important that happened, any psychologists who might want to testify about the impact on the child, doctors who could provide testimony, just all sorts of things that will be able to back up your case. So once that determination is made, then the other parent would get sole custody. It doesn't mean that the unfit parent is never going to have a relationship with the child. They're still a parent of the child and they can still take steps to remedy the situation. They may be able to gain limited or supervised visitation with the child. So they can appeal that decision if they're declared an unfit parent, and they can try to get their rights reestablished. So some things that they might want to do for that would be attending parenting classes, respecting and following all court orders. That one is definitely important. How are you going to argue that you should get your kids back if you are not complying with the restrictions that the court gave you? Maintaining steady employment, seeking mental health support, attending all court hearings, and seeking treatment for drug or alcohol dependency are also definitely things that an declared unfit parent can do to try to get their rights back. Yeah, so in conclusion, to terminate someone's parental rights by declaring them an unfit parent requires a lot of evidence to override the rights that they have. So it's appropriate in very extreme cases, depending on the situation. And feel free to talk to us about your case and what might work for you. Obviously, these are really fact-specific situations. I might not have addressed something that is relevant to you. So feel free to give us a call or ask any questions right now that are relevant to you. Thank you.
Thank you so much, Rachel. So as Rachel mentioned, now is a perfect time to ask any questions that you may have. But as she also said, each case is very specific. We do offer free consultations, so please feel free to give us a call, shoot us an email. You will all be receiving an email after this webinar. For those of you not watching live, you can email us at info@johnsonlgroup.com. And we will be happy to answer any questions that you have. You can tell us about your specific case, and we can also schedule a free consultation so that you can speak with one of our attorneys about your case specifically, and they can answer some questions for you. I'm not seeing any questions come in, but as Rachel said, everyone has a specific case. So please feel free, don't hesitate to reach out, call us, email us, whatever you need to do. We also are active on Facebook, LinkedIn, and Instagram. You can reach out to us through any of those platforms, and you can also follow us on those platforms. You'll be receiving a link in the email after this webinar. You can follow us on any of those platforms to stay up to date with all of our latest webinars, events, and news. So with that being said, Rachel, thank you so much. Thank you everyone for attending and registering, and I hope to see everyone at the next webinar.
Thanks, Sarah. Bye.